Hi, Dr. J. Franklin Schultz here. I want to talk to you today about the George Floyd Justice and Policing Act of 2020 and why you should, immediately after watching this video, contact your United States Senator and tell him to oppose the George Floyd Justice and Policing Act of 2020. This is not because I'm against police reform. There's no responsible police officer, criminal justice practitioner, or police leader who thinks that there's no room for improvement. I am absolutely in favor of anything that supports quality law enforcement and improves public safety, that is data-based and has a great likelihood of improving policing. But this act should really be called the Taking Federal Control of Local Law Enforcement Act, because this is exactly the precipitous slope, the precipice on which we stand right now. And if this act is allowed to become law and signed by the president, which it would obviously be signed by Mr. Biden, we're going to have less and less local control. You know, there's a reason there are 18,000 separate police agencies in the United States, because A, we don't want one big federal police force, and B, we don't want policing to be out of our military. And that is the model that you see in most of the world, both in despotic regimes and in other Western countries. So we are unique in that regard. It is a very libertarian, Republican, and I'm talking about the conceptual libertarian, conceptual Republican, not the political parties, idea to have as much local control. Because when we have the voters electing the city councils and the mayors that appoint police chiefs, and the county commissioners who budget for criminal justice, and elected prosecutors and elected sheriffs and elected governors and legislatures that control state policing, that is where the accountability is. The federal government can step in when it comes to issues of federal jurisdiction, i.e. constitutional violations, which under the 14th Amendment, local law enforcement, any government entity has the same responsibility as the federal government for abiding by constitutional principles. Obviously, no problem with that, but here are 10 reasons why the George Floyd Justice and Policing Act must be defeated, must be opposed, and must be understood. Number one, it is tightening the definition of deadly force. We don't have any problem defining what deadly force is in American policing. This will now include, under federal law, the discharge of a firearm. Gee, I thought we were going to be in favor of warning shots and trying to shoot people in the foot instead of center mass, but any discharge of firearm is going to be defined as deadly force. And that's not really far off from what we do now. We understand that every time we pull the trigger, we have to be accountable for that bullet and accountable for what happens after that. Deadly force will include carotid artery restraints. That is a very useful move that police officers have used to temporarily cut off the blood supply, cause very temporary unconsciousness, very seldom results in lethality, but it's going to be used in a really difficult time to avoid using higher levels of force. So to take away that carotid artery restraint, I believe is a mistake tactically and will actually be counterproductive. And then also included now as deadly force is multiple discharges of an electronic control device. Folks, when the taser has to be used repeatedly, it's because there's repeated resistance, and it's probably because a person is in a high state of agitation through excited delirium, or under the influence of a dose of alcohol or other drugs that cause them not to respond to rational thinking or to pain compliance. And so sometimes these measures are necessary. Most training now says that after X number of discharges, move on to something else. But again, the taser is an intermediate force before deadly force. So if we start defining it as deadly force and we take that out of the toolbox, then we're going to have to go to the next thing, which may be a firearm or something even more dangerous. So ill-advised to make a complete statement like that. Number two, the George Floyd injustice in policing. Now, all right, I don't want to be sarcastic here. Eliminates qualified immunity. You know my position on that if you've seen. But here's the definition of qualified immunity. The defendant was acting in good faith. The defendant believed, reasonably or otherwise, that his or her conduct was lawful at the time when the conduct was committed, and that the rights, privileges, and immunities secured by the constitutional laws were not clearly established at the time of the deprivation by the defendant, or that at such time the state of the law was otherwise such that the defendant could not reasonably have been expected to know whether his or her conduct was lawful. That's all qualified immunity is. It's a good faith, high impact stress decision that the officer makes with no other clear guidance. Now we're going to remove that defense, which is absolutely punitive, unnecessary, and will not further the cause of justice. Number three, now this act will allow immediate access to federal courts from state attorney generals for prosecuting police misconduct or investigating pattern or practice issues in police departments. Now, if you don't know what that is, if there is some evidence that a police department consistently engages in unconstitutional, unlawful behavior, then that can invoke a civil rights investigation by the federal government and can result in basically a takeover of police departments. And this is used as a heavy hammer because police departments usually capitulate. They don't try to contest it or go to trial because that's more expensive than just putting up with being a puppet of the federal government for some period of time. And now we want state attorney generals to be able to hop into federal court. And look, folks, the systems are already there. The federal government doesn't have to be everybody's daddy and come down and solve everybody's problems. We have systems in place at all levels of government to deal with issues of police misconduct, and they are being dealt with, and more severely and more frequently. Number four, we're now going to allow community-based organizations to provide advice and input in police operations. And I don't have any problem with civilians. We need to have civilian control, just like we do ideally of the military, civilian control and oversight. However, when the civilian boards, which may or may not include law enforcement professionals, had the absolute authority to impose policies on police departments, that I think is a tail wagging the dog and very dangerous. And Black Lives Matter is not mentioned as one of those community-based organizations, but I'm sure that's a political intention, and that organization, do some research into that organization. Obviously, lives of Black people matter. That's not a question. But look at that organization, ask what they've done, where they've spent their money, and what net results they've had other than raising awareness. So we don't necessarily want broad day-to-day operational control by interest groups. We want that done by elected and appointed officials who are professionals at what they do. Input, absolutely. Education, absolutely. But not control over day-to-day operations. Fifthly, national uniform standards of training. Now, we have peace officer standards and training boards in every state, and they have standards. They have standards for licensing and certification being revoked, for testing, for minimum standards. So, the issue of training is one that is of concern, but it's not the crisis that people think, because most of the training that is now being mandated and imposed is already being done. We do de-escalation, we do constitutional rights, we do mental illness, autism awareness. We get it. We absolutely do. The profession understands that, and we do very, very well at that. And so to have, again, Uncle Sugar up there in Washington, D.C. mandating these trainings, it is redundant, and it also is going to be a political product. So it may not be the best training for every one of the 18,000 law enforcement agencies in America. It's just federal intrusion, duplication. It's unnecessary. and we don't want one national federal policing or having local police being the puppets of Washington, D.C. policy bureaucrats and wonks and politicians, okay? Sixth, the ways that this is going to be enforced is it's going to be through grants. So we're going to get police departments addicted to federal money so that they end up dancing to the federal tune because the money that they're normally budgeted is going to be displaced. Hey, you're getting all this federal money. And so it's just going to be this big boondoggle where the feds are going to have more and more control over your local police department. The officer driving by your house on patrol, responding to your 911 call is going to be on the strings of the federal government. We do not want that, not in this free democratic society with civilian policing. Another reason, the creation of positive school climates by improving school conditions for learning by eliminating school-based arrests and referrals to law enforcement. Now, if you remember, 20 some years ago, post-Columbine, we were concerned about school safety. We were concerned about juvenile crime increasing. We were concerned about making sure that teachers and staff and administrators were safe from criminals who happened to not be 21 yet, okay? And now we're saying, okay, let's get those protective school officers out of the school building. We don't want anybody to be arrested in junior high. Look, is there a reason to be afraid of a 12 or 13 or 15 or 17 or 18-year-old who may be engaged in violent behavior? And sure, it may be a mental health issue, may be emotional, but listen, violence is violence. If somebody's coming at you with a knife or entering your school grounds with a gun, we really don't want police officers on the ground to help deal with that. This is one of the objectives of this so-called Justice Act, is to get rid of police officers in our schools and not even make referrals to law enforcement. Now, again, in the post-Columbine era, we had laws that mandated the reporting of violence so that we wouldn't have this invisible nest of violent behavior and no law enforcement record of it. You know, if I arrest somebody at age 19, if somebody is arrested at age 19 and there's absolutely no record of misconduct or illegal behavior because we didn't want the police involved with these blessed little teenagers, then it's a brand new start. So that's another reason that I object to it. Another reason is that the federal government is going to require what most jurisdictions already require. Here we go with redundancy, is we want to know about every pedestrian stop, every car stop, every ticket that you write, every frisk and body search that you do. And so police officers are going to have to fill out reams and reams and reams of paperwork, lose millions of productive man hours, and frankly be discouraged, which is probably the real intent of the law here, discouraged from investigating suspicious behavior. And so it's going to be a real, we're seeing this already. And I'll tell you where we're seeing it. You look at the major cities that are having exponential, like 10, 25, 35% increase in homicides, more dead bodies being stacked up in the streets in these cities. It's because of this exact kind of thing where we want law enforcement to stop doing law enforcement. Prohibition of no-knock warrants, absolutely. If you've got a terrorist or a gang member, we don't want you to go to a judge, have the judge review that and say, yeah, this is really dangerous for the law enforcement officers and it's going to result in the destruction of evidence, so we'll let you go in. So we're going to get rid of that, and we're all going to have to go to the door and say, excuse me, Mr. Gangster, Mr. Terrorist, Mr. Drug Dealer, do you mind if we come in and look around a little bit? That's an exaggeration, obviously, but there's no reason to do away with no-knock warrants when these warrants have to be approved by judges already. There's already pre-event judicial review. We're making some of these things civil rights violations. So again, how's the federal government going to assume jurisdiction? Well, if you make it a civil rights violation, then boom, it's a federal issue. So boom, federal involvement. If you get departments and governments addicted to federal money, they take a federal dollar, boom, they're federal puppets. The rules for federal officers, and here's another thing. We see these rules that are being applied to federal officers, clearly jurisdiction. There's almost 80 federal agencies that have arrest powers, gun toting, badge carrying feds. You thought it was just a half a dozen agencies. No, dozens and dozens of agencies, which is fine. But now federal deadly force rules will say that it has to be a last resort and create no substantial risk of injury to a third person, and that reasonable alternatives to the use of form of deadly force have been exhausted. Now, when we say that deadly force has to be a last resort, that means that you have to fail at multiple other options before you use deadly force. Most officers do that. Most policies imply that, if not duplicate this. But when we say these kinds of blanket statements, then we're making a rule that we expect to apply to every deadly force situation. Let me tell you something, both my personal research and the FBI reported research shows that with any given 2-year period, 70 to 80% of police officers will make the decision whether or not to use deadly force. Now, the vast majority of them are able to resolve the situation, but most police officers, and if you talk to anybody that's been out there for very long, have you ever had to make the decision about whether to draw your gun and possibly fire? You'll hear most of those voices saying, yeah, I had to make that decision. Most of those voices will say, I was able to de-escalate. I was able to use an alternative. I was able to retreat and reapproach. So this deadly force issue is not just this rare, oh, you'll never shoot your gun in the line of duty. That's probably true. You will have to decide whether or not to shoot your gun in the line of duty. That is going to be true. So to make these very narrow rules, I understand we don't want to kill people we don't have to kill. But to make these rules and assume that they're going to apply to every situation is just, it's not scientific. It's not true. It doesn't, it doesn't square with circumstances and anatomical, biological, human limitations and the laws of physics. I can't use deadly force if a third person might be endangered. Okay, if I've got a man with a shotgun, he's moving into the schoolyard where dozens of kids are going to be exposed, and there happens to be a jogger behind that person, I can't use deadly force against the attacker because I might hit the jogger, and therefore I have to put everybody else at risk. So that's just one example where these narrow rules are not realistic. And my last point, it's certainly not the last argument, but my last point is, let me make a little more discussion about these federal rules. So, okay, if the federal government is going to impose these rules on federal law enforcement officers, that's absolutely their right, okay? However, when we start going to the feds and now state attorney generals looking at pattern and practice investigations, they're going to say, okay, what is best practice? Well, the federal government has these national standards. The federal government has these standards for their federal officers. The federal government has these commissions that make these decisions. And so separate from what's really going on with the local police department under local accountability, you've got these eyes on all this federal practice, which may be fine, but it may not for one of these 18,000 local government agencies. But now the pattern and practice template is going to be applied to these local agencies. So everything that the feds do, if they start taking responsibility for regulating law enforcement beyond constitutional bounds, they start taking responsibility for regulating local law enforcement, then their standards are going to be applied. And that may not be a bad thing, but it may be a terrible thing, because that can then bring condemnation on local police agencies. Lastly, they're going to cut down on military surplus. Just because something was once owned by the military, a face shield, a ballistics vest, ballistics helmet, safety gear, even the MRAP, the mine-resistant armored personnel carrier. Listen, no police department wants an MRAP. Nobody wants a tank. What they want is the ability to have personnel delivered into a hot zone where bullets are flying in a vehicle that will keep them safe, and to have a vehicle that is bulletproof to move in and rescue somebody in a hot area. Now, you can either pay somewhere between $750,000 or more for a personalized armored personnel carrier manufactured in the U.S. for civilian law enforcement, which is preferable, but most agencies don't have that money. Do small agencies need that? Absolutely. If you ever have a barricaded suspect, if you have an officer or civilian pinned down by gunfire, if you've got a sniper, you need an armored personnel carrier. I've always worked in relatively small agencies, and on multiple occasions, I've seen where a surplus armored personnel carrier had great benefit in rescuing or delivering first responders to a crisis. And so it's something that's really among the basics necessary for police officer, at least have access to them within an hour's response time. So again, nobody wants a military tank, nobody wants an MRAP, but they're affordable because for the minimal cost of transportation and some paperwork, you can get one of those and retrofit it for civilian. Nobody, listen to this, no police agency is running around in tanks or armored vehicles with 50 caliber machine guns routinely mounted on top of those machines. That doesn't happen. I offered a cash reward for anybody who could show me one police agency with a automatic weapon fastened to an armored vehicle. There were no takers. One person said, well, there was this tank being run around as a public relations move, and no, don't worry about that. I appreciate the federal government being afraid that we're going to rain mustard gas and napalm and automatic weapons fire and anti-personnel mines and drones using flamethrower. Listen, that's not happening. It's not the equipment that we want. We don't have any reason for that. So sure, monitor it. Every liberty-minded person wants to watch to see what the armed government agents are doing, but to take away some of these essential tools is ridiculous. Those are just about 10 issues that I find with this George Floyd Act. It is not good for America. It's not good for democracy. It's not good for you as the citizen. Write your United States Senator today. Tell them to stop this type of so-called police reform, which is merely punishing law enforcement, taking tools out of their toolbox, and making you less safe.